Public Protector Busisiwe Mkhwebane, his removal could be paused. The former acting Speaker Lechesa Tsenoli has lodged an appeal in the Constitutional Court against the Western Cape High Court judgment that found that sections of Parliament's impeachment rules were unconstitutional. The appeal comes after the Rules Committee agreed just last week to appeal that judgment. Let's bring in the parliamentary spokesperson, Moloto Mothapo now. Moloto, thank you so much for making time. So you've approached the ConCourt now. What are you challenging about that High Court ruling?
Yeah, indeed, under the name of the Deputy Speaker of the National Assembly, we have made a direct application for leave to appeal to the Constitutional Court. This, of course, was done while at the same time another application was made to the full court of the first instance, which is the Western Cape High Court, for a conditional application for leave to appeal to the Supreme Court of Appeal. This as a contingency, being that the Constitutional Court refuses the application for direct leave to appeal. So in summary, although the court in general found the new rules regarding the removal process of the public protector to be constitutionally sound and dismissed the challenge by the public protector, the court did express reservations on two issues, which are the provisions in the rules that the legal practitioner assisting the Chapter 9 institution head may not participate in the committee. And they have removed that as part of rewriting the rules of the Assembly. And secondly, the reference to a judge in the rules has been removed. And this appears to be premised on the finding that an appointment of a judge to the independent panel offends the principle of separation of powers. And there appears to be some also ambiguity in the findings of the court, specifically as the High Court does not completely close the door to a judicial appointment when appropriate, regardless of the position taken in its order. So more pertinently, the court does not pronounce itself on the status of the independent panel as a report on the current process or the implication on the current process that is ongoing within the National Assembly. So while we are approaching the Constitutional Court and simultaneously as a contingency the High Court, so that if it is not accepted by the Constitutional Court, we are able to appeal to the Supreme Appeals Court. The Speaker of the National Assembly will advise the committee itself to take a decision with regard to what it would want to do while these matters in court are being dealt with.
Yeah. What are you recommending should happen? What is the Deputy Speaker recommending should happen in the meantime regarding the impeachment hearing? Because the issue issue has been whether even now, even if the High Court order is confirmed, the question is, does it invalidate the proceedings so far? The Public Protector's Office seems to believe that High Court order is supposed to then send Parliament back to the drawing board.
Well, that is their own opinion. It is not the opinion of the court. As we are saying, the High Court is silent on the matter of the implication of its findings on these two matters to the process that is currently ongoing in the Section 194 committee. So that is the reason why the Speaker of the National Assembly will have a meeting with the chairperson of that committee, so that the committee can actually look into these matters that are being dealt with in court. Probably the advice will be that, in the interim, out of respect for the matters that are before the court, or we want the court to deal with, the committee may in the interim deal with, administrative issues, preliminary issues, rather than the thrust of the inquiry into the fitness or otherwise of the public protector to hold office.
All right, Moloto Mothapo, parliamentary spokesperson, thank you so much for making time this afternoon.